Hello, everyone. To all of our esteemed speakers and audience members, you are very welcome. This is a very exciting discussion we're having today. We've just had wonderful contributions from a variety of scholars internationally as well as practitioners, which was very stimulating, and we're looking forward to another very engaging discussion. So we have 8 panelists speaking in the next 2.5 hours. We will have a question and answer session at the end. Anyone who would like to ask a question, feel free to post that in the Q&A tab at the bottom of your screen, and there's a sidebar link where we'll be able to read those. I just wanted to introduce myself again for those of you who are only tuning in now. We have a number of speakers here in this time slot who are speaking from the US and Canada. So I imagine that a lot of the audience who are tuning in from the US have only come in now. So just to say, my name is Dalla. I'm an assistant professor here at the Trinity College Dublin School of Law. If you don't mind, I'll use first names, and please do the same for me. I was reprimanded by Juan Mendez on Monday for using the official titles too frequently. So we will keep this informal and friendly, and hopefully that will be an enjoyable approach to take. So a couple of thank yous, and then without further ado, I'll hand it over to our first speaker. Thanks to Robert Morgan, our research assistant, to Maeve McGrath, Sean O'Brien, to Donald and Patricia Lyons for their substantial assistance. They're tuning in from Montpellier. To the law school, of course, to our funders, Society of Legal Scholars, and the Faculty of Arts, Humanities and Social Sciences here in Trinity. Thanks so much to the audience and everyone tuning in today, and especially to our speakers. So Professor Eyal Benvenisti will kick off this second time slot. Eyal was a lecturer of mine in New York University in 2008-2009, where he taught international humanitarian law, and has been a big inspiration for me, and he has had a huge impact on the direction my career has taken. So Eyal Benvenisti is Whewell Professor of International Law, as you all know, and Director of the Lauterpacht Centre for International Law at the University of Cambridge. And Eyal circulated a paper in advance on the World Health Organization and challenges that faces in the context of the pandemic. So I would like to hand the floor over to you, Eyal, if this is a good time.
Yeah.
Thank you.
Thank you very much. Thank you for inviting me. I'm delighted to share my ongoing work with you. It's a beginning of a project. I've never examined the work of the World Health Organization, and only since the beginning of the pandemic, beginning of February, I started thinking about what is going on with the organization. So for me, it's probably the second opportunity. The first was internally with the people at the Lauterpacht Center. The second opportunity to present it to a wider public, and looking forward to comments. So I begin with a more abstract theoretical point of view, discussing types of problems for international action, problems that international organizations are designed to address. And I focus on two types of problems: coordination and cooperation. Coordination is setting the rules for the road. You drive on the left or the right, what you do when the signal is red or green. And cooperation requires overcoming collective action problems. You have to share a collective burden for you and for the collective to succeed in resolving a problem. And IOs are designed either for coordination or for cooperation or for both. So types of coordination issues that are resolved by IOs are among the first IOs, or maybe the first IOs, the International Telegraph Union, 1865, and the Universal Postal Union. So there are problems that could be resolved by, flip of a coin, what to do when the signal is red or green, but there are other issues like what do you do if the standards benefit some rather than others? Some benefit more than others. So for example, if we take the postal issues, how do you allocate revenues if some states send more postal items to another state? How do you allocate the imbalance if the flows of the post are imbalanced? Or what do you do with developing countries? How do they get a lower rate? So the question here is how to design the standards so that everybody accept, despite the fact that some benefit more than others. The other type of IOs are ones that address also address questions that require states to bear a certain burden, and they have an interest, a strategic preference to cheat where others benefit. So I would not clean my sewage, hoping that other countries will clean theirs before they reach a collective lake. So in this case, standards might be backed by monitoring and enforcement mechanisms through independent actors within the IOs, like judges or bureaucrats, as we have in the WTO or the OPCW that handles chemical weapons. So these are the two types of problems that IOs face. Now, what about the WHO? Is it about coordination or cooperation or both? So initially, when it was set up, or before it was set up, the thought was, or at least was presented, as an IO that is about coordination. Identifying missions are to identify and to disseminate information about pathogens and about treatment. And there is an underlying assumption that there are common interests and common interest in common goals. So everybody will benefit. All states wish to promote the citizens' health, and all states realize that doing so requires reduction of health risks throughout the globe. And there is this is why the WHO treaty is called a constitution, and in its preamble, among other things, it emphasizes the idea that unequal development in different countries in the promotion of health and control of disease, especially communicable disease, is a common danger. So the danger for all, and for that very reason, it is ruled by non-political experts, chosen from among the persons most qualified by their technical competence in the field of health. And the World Health Assembly, who's authorized to set standards and policies, can do so by a 2/3 majority, acting and voting, that is binding on all state parties without ratification unless those parties formally opt out. And there's no provision for exiting the WHO constitution, probably because nobody thought somebody would have any interest of doing so. So this is maybe the myth, the founding myth of the WHO. It is about coordination. It's like red and green light. Everybody would follow the rules set by experts. But this premise of common interest was questioned at the outset. And we have one hint for that. A lecture by Melville Mackenzie, who was an expert, a British expert, in 1944 to an American audience. He's saying, in practice, it is impossible to expect more developed countries to be overruled by the votes of nations less developed from a medical and social point of view. I interpret it as to say, science is Western, and hence expert rule is Western rule. And in fact, dissension about common goals and how to attain them started immediately following the establishment of the WHO, when the Soviet Union wanted to convince the WHO to recognize the intimate link between poor working conditions and health problems. So health is not only about medicines and selling pharmaceutical remedies, but it's also about providing for a equitable social health to all. It failed to convince WHO, and it left the WHO for a couple of years. Now, the turning point of Western domination comes in the early 2000s, with the rise of the South, and we have two moments, both of them in 2006. Indonesia demands that northern pharmaceutical companies pay for the DNA that it provides, DNA of viruses that it provides, or at least provide access to its citizens to the drugs that pharmaceutical companies develop from the viruses. So there's ongoing negotiation that ensues, and there's a resolution that is never satisfactory from the point of view of the South. And another moment comes when a Chinese candidate is elected to the Director General of the WHO, and since then, is either the candidates are either Chinese candidates or supported by China. All of them supported by China, but Margaret Chan in 2006 was the Chinese candidate. So the first challenge to the idea of the myth of WHO as an apolitical coordination institution is nowadays the South-North conflicts about allocation of burdens and benefits, among other things. Now, to the second point about, is the WHO also about cooperation? And here comes the second, I think, more devastating challenge to the WHO. Global health, we now realize, is a collective action problem that requires cooperation, because states have and always had a dominant strategy to act unilaterally. Source states would underinvest or take more risks or deny an outbreak, while and because trading partners would close borders defensively, as Professor Ostrop noted in, last year, fail to provide foreign aid or otherwise respond excessively to risks coming from source states that are in the past have been in the South. And in fact, I want to argue that global health management poses one of the most complex cooperation problems we have, like climate change probably. And to do this, I want to compare the challenges of global health management with the trench warfare that, you know, people mention as indication of the possibility of international cooperation, which is one of them is the trench warfare in 1916, the tit for tat that developed in the trenches between the Allied forces and the Germans. Now, there's a fundamental difference between cooperation in World War I, and cooperation in global health. And I want to emphasize three distinct factors that exacerbate the problem of global health. First factor is scope. Is it a single issue? You know, shooting or not shooting, or protecting bluefin tuna or not? Or is it a multiple issues that involve multiple issues like economy, human rights, trade, tourism, etc. Question of frequency. Is it the exchange? Is it frequent, daily, hourly basis, or is it intermittent, which makes makes parties more unsure of their opponent's position, whether they continue to commit to cooperate or they decide to act on their own. And finally, vulnerability. Are the parties situated in the same relative vulnerability from the other, or are they in a dissimilar situation? One is affected more than the other, like upstream, downstream riparian in a shared river. Cooperation in the trench warfare, I think, was simple because it was based on a single issue, it was frequent, and parties were relatively similarly vulnerable. Whereas in health, global health, there are multiple issues involved. Frequency is intermittent so far, and parties are in dissimilar situations, so some may be harmed more than others. And this, I think, what makes cooperation in the health sphere very, very challenging. So two challenges, both to the coordination aspect and the cooperation aspect. The South-North conflicts, and they have to be, or expected to be, managed by an organization that was deemed to tackle only issues of coordination, and hence had no tools to monitor and enforce compliance of a very complex collective action problem. Now, there is one story that I think captured the whole issue, which is the SARS pandemic 2002-2003. At the time, the WHO was fortunate to have Gro Harlem Brundtland, the former Prime Minister of Norway, as the Director General, and her committed staff. And they were able to overcome the inherent problems, institutional problems with the WHO, and they were able to coordinate and to seek cooperation by obtaining independent information to identify the pathogen. They were able to send teams of experts into countries to ensure compliance with the course of treatment that they recommended. The WHO issued global alerts, imposed travel advisories, or actually announced travel advisories, including for Toronto, which made the people in Toronto furious about the WHO. And it shamed and even blamed China for not reporting the earlier phases of the outbreak, putting the blame on China for the pandemic. So lawyers responded by saying, well, how did they do it? They acted ultra vires. They had no authority to do so. And Professor David Fiedler, who was in favor, who supported the WHO, nevertheless said this was a governance revolution at the time. And that was not the end of the story. The end of the story was with the adoption of the 2005 International Health Regulations. The opportunity came 2 years after the effective response to the SARS from governments who successfully utilized the final stages of the revision process to stress the subservient nature of the WHO, and in particular, the need to consult with and obtain the permission prior to replicating many of the actions that proved so effective in containing SARS. The gist, and I won't go through the articles of the IHR, but the gist is that source states monopolize information, even chilling prospective whistleblowers, because the requirement is that the WHO shares with the source state the information that is privately provided to it. And trading states retain full discretion to quarantine, and there's no monitoring and shaming of states that acted excessively. So there was actually an agreement between the South and the North to disagree. And expectedly, failure of the WHO followed in 2009, 2014, and review committees were set up by the WHO, but they ended up with the expected results. The world is ill-prepared to respond to a severe influenza pandemic or to any similar global sustained or threatening public health emergency. This is the conclusion of a review committee from 2011, and the one from 2016, probably realizing that there's no political will for any sanctions regime. They opt for shaming and for probably possibly developing standing recommendations that might be relevant for WTO litigation concerning trade restrictions that might run afoul of the WTO by GATT rules. No standing recommendations have been adopted since 2016. So the conclusion, is it destined to fail, or was it even designed to fail? The IHR 2005 undermined coordination because they provide limited ability to obtain and disseminate information, and it undermine cooperation because it limits monitoring enforcement powers and state obligation to provide information, and assume risk is really minimal. Now, I see I have no time, but maybe in the Q&A, I would like to share with you some ideas about possibly alternative global health regime, which will be based on private markets and cooperation by industry. All of those, and there are many who are invested in stable economy. So a privatized, just one word to say, the first notice about a pandemic or an outbreak in Wuhan came from a company in Toronto called Blue Dot, who was surfing and analyzing social media. And they were able to say that there is a pandemic, and they were able also to predict where people will fly out of Wuhan, because they knew who brought airline tickets to where. And so there is a lot of promise in privatized systems. And I think most of the attention should be paid on the alternative to the WHO, because I don't see any, in the current geopolitical conditions, any prospect for effective improvement. Thank you very much.
Thank you so much, Eyal. That was so interesting. Thank you for bringing your expertise to the table here and for opening the discussion on the World Health Organization and alternative actors. The World Health Organization, obviously an organization that's truly at the forefront in the context of the pandemic, but it's important also to see the downsides and to face the challenges. that exist in that organization. So we're delighted to have Professor Eric Posner replying to that paper, and I wanted to just check, yes, that you've arrived. Hello, you're very welcome. Professor Posner will reply directly to Eyal's draft paper. As you all know, Eric Posner is Kirkland and Ellis Distinguished Service Professor of Law and Arthur and Esther Kane Research Chair at the University of Chicago Law School. And this is the only instance in this conference where there's a direct reply to a draft paper. So there will be an opportunity just before the questions and answers for Eyal and Eric to come back in and briefly to reply to issues that have been raised. So without further ado, I'll hand it over to you, Eric. Thank you.
Thanks, Donna. I'm sharing the screen. I trust you can see it. I only have 2 slides. And the main reason I'm putting them up is when I taught over Zoom to my students last term, they thanked me for using slides because they said otherwise your face fills up the screen, and that's just horrible to sort of stare at this gigantic face talking at you for 2 hours. So for the benefit of the audience here, I'm putting up a slide. Also, Donna, thanks so much for organizing this conference. It's terrific that you're able to do this under these conditions, and it's a thrill to be able to participate, and especially to comment on Eyal's paper. I'm a huge fan of Eyal's work, and you know, actually, I too was thinking about writing a paper about the WHO earlier this summer. You know, it was just something that obviously had to be discussed. There's not much of a literature on the WHO. And I actually started a paper, but I'm very glad Eyal has gone ahead and written a really terrific paper. It makes my life a lot easier. I can read and learn. And I'm going to offer some comments now, which are not really critical. I think Eyal is basically right. I agree with his general analysis of the WHO, but what I'm going to offer are some, you know, different ways of thinking about this problem he identifies, and some suggestions for him as well. So as everyone should know from listening to Eyal, he has a simple and powerful argument about why the WHO is in trouble. And he starts off with this distinction between coordination problems and cooperation problems, which have been analyzed extensively in game theory. And his basic point is that, you know, you might have thought that the problem of global infectious diseases and contagion is really a problem of coordination, and one that just called for technical expertise, in which case one could be very optimistic that an international organization could be set up to handle the problem. But as he points out, and I think he's absolutely correct about this, it's really more of a collective action problem or cooperation problem. And unless conditions are, you know, very favorable, it's very difficult for countries to overcome these types of collective action problems. Now, so my first thought about this argument is that I think that rather than drawing this general distinction between coordination problems and cooperation problems, it's best just to start off with a model, an informal model of the problem of global infectious diseases. And that's what I've put up here on the screen. And I should say, you know, this model is fully consistent with Eyal's, but it's somewhat simpler, and I think a little bit easier to understand as a result. And so basically what we have here is what I call an outbreak country, a country which suffers an outbreak of an infectious disease. And then we have what I call the rest of the world, which is, as Eyal points out, very complicated construct. The rest of the world is not a single entity, but a group of countries with conflicting as well as overlapping interests. Now, the outbreak country, you know, as Eyal says, would like to keep the pandemic, the outbreak, secret. It wants to disclose it as late as possible, because there's some probability that the outbreak country will be able to suppress the outbreak. Nobody needs to learn about it. Everything's fine. Of course, if the outbreak country is unable to suppress the outbreak and it crosses borders, then the rest of the world is harmed. So the rest of the world would like to learn as soon as possible that an outbreak has occurred so that it can close its borders, basically, restrict trade and migration in order to prevent the infection from spreading. The outbreak country would like to delay disclosure as long as possible. I mean, ultimately, the outbreak country will probably want to reveal the infectious disease because it can't be hidden, and it would like help from the rest of the world. So this is the basic conflict of interest, and you can think of the WHO system as a really simple and in a way quite elegant solution to this problem. And I think despite Eyal's pessimism, we shouldn't, rule out this type of solution, and I don't think Eyal does. But the solution is just a deal, okay? So that is an agreement between the outbreak country and the rest of the world. And of course, the outbreak country could be any number of countries. I'm abstracting from the identity of a particular country that suffers an outbreak. So the outbreak country basically says to the rest of the world, we'll give you the information earlier rather than later so that you can protect yourselves. And in return, the rest of the world is going to give the outbreak country help, expertise and resources, basically, money and expertise. And at least in principle, this deal is in the interest of both sides of the outbreak country and the rest of the world. Moreover, this deal should be self-enforcing, basically along the lines of the trench warfare example that Eyal gives us. It's really, the real question here is whether the rest of the world's promise to help is credible or not. The outbreak country, when it's deciding whether to reveal information about the outbreak earlier rather than later, needs to be able to needs to be able to trust the rest of the world, the promise that the rest of the world makes that it will offer aid and not react too harshly to the outbreak country. But it's in the interest of the rest of the world to be responsive, because if the rest of the world does not help the first country that suffers an outbreak after the regime is put into place, then subsequent countries have no incentive to reveal information earlier rather than later. Okay, that's it. Very simple, very elegant, and as I said before, I think this is very much consistent with Eyal's analysis. The role of the WHO, by the way, is in kind of a surprising degree. It can be perfectly passive. It doesn't have to have enforcement powers, whatever that might mean. All it has to do is administer this deal by. It can be a repository of expertise that's supplied to the outbreak country when the outbreak occurs, and it reveals the outbreak to the rest of the world. It can set the rules to some extent. But it doesn't have to, for example, have the power to slap sanctions on the outbreak country if it discloses too late, or the rest of the world if they provide inadequate resources. Okay, that's the deal, and note that I don't have to say anything about the cooperation problem or the coordination problem. It's just kind of implicit in the nature of the deal. So the question now is, why did the system break down? And the way Eyal talked in his presentation and a little bit in the paper, there's a kind of a very there's very much a tone of pessimism, which I think is certainly justified now. But the WHO was actually a pretty successful international organization by the standards of international organizations. It was, as far as I know, instrumental in the eradication of smallpox. And of course, the story of SARS that Eyal gave us was actually a successful story. It was only the subsequent reaction that was the problem. So there was nothing, there's nothing inherently wrong with this structure. And so I wouldn't say that at the start the WHO was designed to fail, if that's what Eyal thinks. I don't think that's what was his real point. But in any event, I do want to make clear that there was no reason to believe from the beginning that the WHO could not work. But what did happen? Well, I mean, first, let's just start with some theoretical points. It's always possible that this type of deal is not actually in the interest of these particular countries. So the outbreak country suffers a real loss when it tells the rest of the world that it has an outbreak, if it's possible that it could have suppressed the outbreak secretly. It's going to suffer loss of trade and so forth. So that's a big loss. And so the deal has to be generous. The help coming from the rest of the world has to be generous enough that it's worth it for the outbreak country to reveal this information. That may not be the case. And it may not be the case with a country like China today, the way it may have been the case for China 20 years ago. China is a different country now from what it was 20 years ago. And this is true about a lot of countries. A lot of countries that we still call developing countries are actually, reasonably wealthy. They have, good institutions. They may not need the help of the rest of the world as much as they used to. While they may be more sensitive to a loss of trade or migration. The second big problem, which Eyal, does talk about, is that what I call the rest of the world, this is a bunch of different countries with conflicting interests. So if we wanted to do a better diagram, I would have 194 countries here rather than just one box, which would be a little hard to see. Now, the problem here is there's a classic collective action problem that's easy to understand, which is that the other countries may disagree about how to divide the burden of the help. The help is expensive, hundreds of millions of dollars, billions of dollars, and some countries might say, we're too poor to pay a share of that. Other countries might say, we've got other pressing problems. There are all kinds of conflicts, of course, because all countries are different. If a country borders China, maybe it'll be more worried about, or any country where an outbreak is likely, it might be more worried about an outbreak than a country that's far away. There are all kinds of difficulties and imponderables. So it may be, it may be very difficult for the rest of the world to cooperate. And then there are other types of complexities and asymmetries. Countries in the rest of the world might have different relationships with the outbreak countries. Some might be allies and some might be hostile. And this can also undermine cooperation. And the final point is, which I think is interesting and something Eyal might want to think about, there's always a question about whether an outbreak country might think that it really needs the help of the rest of the world. And this is a little bit related to Eyal's interesting comments about private aid. So, a poor country with an outbreak, it might think, first of all, look, even if I delay disclosure of the outbreak, the rest of the world's got to help me, because if they don't, it's going to spread even more than it would otherwise. So they're, a big part of the deal on the screen is that the rest of the world has to credibly threaten to punish a country if it doesn't report its outbreak in a timely fashion, but the rest of the world might find that it's actually not in its interest to punish that country. In fact, its interest might be to help that country. And then the point about private institutions, the outbreak country might think, look, even if the rest of the world ignores me, there's always the Gates Foundation, there are independent scientists at research universities around the world. They're all going to come in and help me. They're humanitarian organizations. They'll come in and help me. I don't need the rest of the world. And so the deal falls apart. The outbreak country might think it makes more sense for me to delay disclosure than to do it in a timely fashion. Eyal's, I think, discussion of the SARS outbreak and the response with the IHR is very powerful. I don't know anything about it. I'm taking his description. I'm assuming it's correct, but it's just it's a kind of an illustration of the sorts of problems that can arise because of I'm sorry. I just want to make sure I'm on time. I guess I should finish up. So the sorts of problems that can arise because of these conflicts of interest that I've been discussing. Okay, let me just make some final thoughts. So, an enormous omission in Eyal's paper is, of course, the United States withdrawal from the WHO. I assume in the next draft, Eyal is going to want to talk about that. What should we make of it within his framework? And I think there are a couple points one could make. So first, we could say, well, this is just a kind of a Trump-specific action, and it doesn't really have anything to do with world politics. And when Trump is gone and replaced by a more normal U.S. president, the United States will re-engage with the WHO. I think that's actually pretty plausible. But another way of looking at this is that what's really going on is that the rivalry between the United States and China is heating up. And this is really the source of the US withdrawal, because the US is not only blaming the WHO, it's blaming China. Of course, part of this is is the attempt by the Trump administration to distract the public from its own mistakes. But I think it's the argument is being treated seriously by receptive public to some extent because of growing suspicion about China. And the lesson here may be that while there's nothing inevitable about the decline of the WHO, it may be more that the WHO's ability to be successful is a function of global politics. And as like back in the old Cold War, if one country's gain, if one superpower's gain is seen as a loss or a relative loss by the other, then the scope for cooperation diminishes. And that may be the real problem right now with the WHO. And with that, I will stop. Thank you very much, Donna and Eyal.
Thank you very much, Eric Posner, for those compelling and insightful comments on Eyal's draft paper. It really is a fascinating discussion, and it's something we can come back to at the beginning of the Q&A, so there will be an opportunity for a short reply then. So thank you again, and this is a really good moment to move from the World Health Organization and global governance in relation to that to issues around health and the right to health, as well as the future of that right in the age of COVID-19. So I'm delighted to welcome Professor Lisa Forman, who is Canada Research Chair in Human Rights and Global Health Equity and Associate Professor at the Dalla School of Public Health at the University of Toronto. Lisa will talk about the future of the right to health in the pandemic context. And without further ado, I would like to hand the floor over to you, Lisa.
Thank you, Donna. I want to just say what a pleasure it is to participate in this conference. And I want to thank Donna for inviting me and congratulate her on putting together such an extraordinary panel of speakers. It's such an appropriate time to be talking about international law and its interface with global health law and institutions, given the incredible pressures that COVID is placing on the norms and institutions of international law. And these pressures come not just because of the epidemiological nature of COVID, but because of the political context and moment in which COVID has come. It's a time when international law, institutions, and norms are under tremendous attack, and a time when health systems, universal health systems, and social determinants of health have been eroded in ways that appear to be undermining responses to COVID. So what I'm going to do in my time is explore the argument that this political context deepens rather than undermines what international human rights law and the right to health in particular have to offer when it comes to COVID responses, whatever the weaknesses of the norm and whatever the weaknesses of the system. I'm going to suggest that the right to health can ground COVID responses in universality, equity, and fairness, that the right to health offers an interpretive norm capable of ensuring greater integration between the fragmented international law regimes of human rights and the international health regulations, in addition to the important tool that it provides to civil society to constrain abuses of power during COVID, and in its function as a countervailing norm to the larger ideological battleground on which domestic and global health policy decisions take place. And if COVID is a crisis that is likely to transform these norms and institutions, we don't know whether this transformation is going to be for the better or for the worse. And I think that this makes the imperative to defend and strengthen international law, norms, and institutions all the greater. So what I'm going to do in my time is sketch out some of these broader challenges and how they play out in COVID, and complement as a complement to the presentation that Eyal and Eric provided, and then hone in on two particular contributions that the Right Health can make in COVID responses. And if there's time, close with thoughts about what COVID as a specific form of crisis might mean for the evolution of international law on health. Maybe the place to start is with the fact that experts in global health have been warning of the inevitability of a pandemic like COVID for a really long time. And I think this makes it really fair to ask, if this is the case, why were we so apparently unprepared for COVID when it came? And I want to pick up on Eyal's argument that the WHO and the international health regulations were not necessarily built to be fit for purpose, by enlarging on a larger political and ideological context, which have made the likelihood of strong international legal rules and institutions related to global health so unlikely, and which have also left so many health systems under-equipped and ill-equipped to respond to COVID. Now, something that quickly emerged when COVID hit was how many countries had deprioritized pandemic preparedness. The very famous example is the US 2 years ago shutting down a White House office on pandemic preparedness and generally slashing CDC funding. But we've seen similar actions in other countries. The UK delayed a response to a 2016 pandemic simulation exercise, which showed how ill-prepared the country was as it was dealing with Brexit planning. And here in Canada, 2 years ago, the government cut its stockpile storage of critical medical supplies by a third. Now, we can attribute some of these cuts to the rarity of a truly global pandemic, something Claire Wenham suggests creates a disincentive for elected governments to address crises, because those crises are very unlikely to occur while those governments are in office. And certainly the ascendance of conservative governments in the US and the UK has played a role. But I think that austerity policies, which became entrenched after 2008, have also contributed. And these saw significant health budget cuts in high and low income countries alike, through the three countries the examples that I gave: Italy, Spain, Ireland. And these cuts took an even deeper hold in low and middle income countries, with a reported 2/3 of low and middle income countries significantly reducing social and health spending after 2008. And this austerity emphasis on reduced social spending is a very natural outcome too of the dominance of neoliberal economics and policies and logics that has dominated global policy for decades, and which generally promotes the deregulation and commodification of healthcare as not just fiscally responsible, but often as the price of entry for low and middle income countries into the global economy and into international financing, contributing to the broader underfunding of health systems in ways that has made effective responses to COVID harder in high income and in low and middle income countries. And I'm going to suggest that that neoliberal logic has also insidiously and fundamentally shaped global health policy, which tends to focus and prioritize technical, commercial, vertical solutions to global health problems, rather than systemic health system reforms or interventions. And we see some of those tensions which play out with universal health coverage under the Sustainable Development Goals, which even before COVID had been showing some troubling regressive trends, with insufficient domestic and international health financing and catastrophic health expenditures continuously growing since 2000, not receding. So if you have under-resourced health systems being overwhelmed by COVID, and COVID testing and treatment costs being pushed onto people, it's a terrible cocktail for health system failures and for higher mortality from a range of causes, and for people to be pushed further into poverty and insecurity. And I think it partly explains why we've seen ostensibly universal health systems in places like Italy, Spain, and the UK struggle to respond to COVID, and why COVID and the likely inevitable years of austerity that it's going to provoke will deeply threaten likely the realization of universal health coverage in low middle income countries. But I'm going to suggest that this context and its systematic deprioritization of health also explains why international rules and institutions on health are so unlikely to be given teeth. Now, the other significant trend is one which we all know very well, which is the global democratic retreat and rising nationalism, which is not just opposed to international law, human rights, civil society, and the media, but also to science and to facts, as the Trump and Bolsonaro regimes are illustrating. So that COVID responses in those countries are not simply deprioritizing standard public health responses to outbreaks like contact tracing, testing, and care, but are politicizing the pandemic in ways that have demonstrably reduced compliance with measures like social distancing, quarantine, testing, and mask wearing, and are contributing to the failure of public health responses to COVID. And I don't think it's a coincidence that we're seeing the highest death rates from COVID in the world in those three countries with the most politicized responses to COVID: the UK, the US, and Brazil. Now, another aspect of this context which is playing out with COVID is how significantly inequality is driving infections. And there's a significant emerging evidence base during COVID showing that the risk of infection and the risk of far more severe illness and deaths increases not just along an income gradient, but according also to factors like race and indigeneity, because of the increased prevalence of underlying medical conditions and decreased access to healthcare in those groups. And I think that broader context really underscores why human rights, and particularly the right to health, have such an important contribution to make to COVID approaches. This may seem like a very strong argument to make about a very deeply contested right like health, but I'm going to suggest that there's a significant power and force in the way that in the extent of the legalization of the right and in its norms. It's entrenched throughout the international human rights treaty system. It appears in all the regional systems and in a majority of domestic constitutions globally. And treaty text and interpretations of those texts suggest duties with obvious significance for COVID, from a specific duty in the International Covenant on Economic, Social, and Cultural Rights to treat, prevent, control epidemic, endemic, and other disease, and ensure medical service to all who are sick, which the UN Committee has interpreted to include a duty to create systems of urgent medical care, and a duty to more generally assure good quality, affordable healthcare for all. So these aspects of the right have obvious relevance for COVID responses, as do other significant right to health principles, particularly its overarching priority on the assuring the health and care of marginalized and vulnerable populations, the priority on core obligations and essential health needs, on necessity and proportionality when rights are restricted in service of collective interests like public health. And these, I think, are relevant not just from the perspective of binding legal duties, but as principled criteria that can guide COVID responses, from access to affordable care to the adequate allocation of resources to what access to a future vaccine might look like. They certainly can also offer a complement to the bioethical reasoning, which is fairly dominant in a lot of COVID decision-making, and as a complement to the principles of equity, and potentially as a correction to the overemphasis on utilitarianism, which we sometimes see in bioethics. But I'm also going to suggest that the right to health has an important role to play in interpreting the international health regulations, given a significant functional overlap between these two areas of law, instruments of law. And I think it's arguable that the right to health could offer a principle for the kind of systemic integration that the 2006 International Law Commission report on the fragmentation of international law suggested is needed to ensure that the common good of humanity is not reduced to the interests of any particular one regime. And this is an argument that finds scholarly report from prominent global health scholars like Lawrence Gostin and Bridget Tobes, who suggest that the right to health could act as a core unifying standard and pillar in international law related to health. Now, the international health regulations itself have very sparse references to, explicit references to human rights. But there are far more, I think, significant implicit overlaps between the regulations and the right to health, which I think offer equally, if not stronger, grounds on which to view the right to health as a relevant view, a rule of international law for interpreting the international health regulations as contemplated under the Vienna Convention on the Law of Treaty, particularly given the synergy between the status of purpose of the IHR being to prevent, treat, control, provide a public health response to the international spread of disease, and the covenant duty that I mentioned to prevent, treat, and control epidemic. Now, the overlap's not, it's not complete. There's a significant disjuncture too, and I think that'll be a significant challenge for using the right to health context, in this context. But I think there are a range of other places in the international health regulations which have implicit overlaps with the right to health and with human rights more generally. From the duties to strengthen national core capacities, apply measures in a transparent and non-discriminatory manner, not use more invasive and intrusive measures than are reasonably available alternatives, engage in collaboration assistance. These are strongly consistent with right to health duties around pandemic control, with core obligations and not the emphasis on non-discrimination, and rules around the restriction and derogation of rights more generally. There hasn't been a significant focus in international legal scholarship exploring the relationship between human rights and the IHR and the right to health in particular. And I think COVID is illustrating two areas where this relationship is particularly important. The first is where the international health regulations can help realize the right to health insofar as they can be effective controls, an effective mechanism to address pandemic disease, and where international health regulation duties restrict the right to health and service of public health, particularly given evidence which is emerging from this pandemic and past showing how quarantine can weaken health systems, restrict access to essential healthcare, and increase health and social problems considerably. And this is really a part of international that needs development. The Syracuse principles have been generally applied to the right to health in General Comment 14, but we don't have a general comment that interprets Article 4 and 5 of the International Covenant on Economic, Social, and Cultural Rights, and which governs limitations and restrictions. And there's no specific expansion of any of these rules in relation to the right to health. And I think these are probably areas of research that I imagine COVID will propel considerably and will become increasingly relevant, particularly if, as it appears, the international health regulations are reformed post-COVID. So I'll close by returning to the apparent paradox of suggesting that the text and institutions of international human rights law and health can feasibly counter the economic and ideological forces contesting both human rights and effective global health responses to COVID. And I'm going to suggest here that the power of a human right like health doesn't simply reside in its legal text, which we know is fraught with challenges, but in its more inherent force is a very powerful idea about the worth and dignity of all people, which beyond its instrumental uses in law and politics can deeply impact agency and identity among stigmatized and marginalized people. And I think it's significant to note that one of the most successful right to health campaigns of modern era was that for affordable antiretrovirals in low and middle income countries. And I think that this campaign showed the inherent power of a human rights idea to transcend textual and legal weaknesses that we see in the treaties and to capture the public imagination in ways that provoked right to health consistent actions from global institutions and powerful state and non-state actors. And I think the lessons of one pandemic when it comes to advancing the right to health are surely exponentially true of COVID, which policymakers and the public cannot externalize as something that happens out there. And I think there's a potential for COVID as a crisis, like HIV, like other historical crises which have fundamentally transformed international law, to do something similar by surfacing the biases of political systems that deprioritize public health and by reinforcing the need for stronger norms and institutions to protect global health. And I'll end on that hopeful note.
Thank you so much, Lisa, for that excellent and thought-provoking presentation on the right to health. It's so interesting. And I think this is a perfect moment to hand over to Professor Sharifah Sekalala, who is an associate professor at the University of Warwick. And Sharifah will talk about non-state actors and the state in the time of COVID-19, analysing increased public health surveillance. So we're delighted to welcome you, and the floor is yours, Sharifah.
Thank you, Donna. Thank you very much for having me. This is a really excellent panel thinking about public international law, and I'm really pleased to be here. So I'm going to focus largely on non-state actors and their increased scope in international law, and it follows on very closely from ideas presented by both Eyal and Lisa in their excellent presentations. So public international law has always focused primarily on state actors, and the founders of the WHO always thought of global health law really as a public international law project, as evident in the WHO Constitution. And Eyal makes these good points about notions of coordination and cooperation being essential as part of this project in his paper, which was attached. However, global health law has always struggled in terms of articulating this project with ideas of whether it's a public international law project or a private international law one, because of the different regimes that we see in public health. So the state has always been on much shakier ground in asserting a kind of its dominancy because of these competing regimes that I think are much predominant in this area. So we see these tensions in different regimes like the international trade regime, and we've seen previous attempts in global health law that attempt to find this balance in WTO agreements, like Lisa mentioned, with access to essential medicines. But it's much, much harder, I think, for within this context, because the kind of the right to trade under WTO agreements that are much more certain, have higher compliance mechanisms, as Eyal pointed out, reasonably make much more traction in this area. And so we've seen much more problematic tension within the imperative for free trade and the rights to regulate public health at the national level. We also see this in other areas such as sanitary standards for food and agriculture, and the focus on IP rights, which we saw at the height of the AIDS pandemic, and the way in which it articulates these differences between private and public law that is problematic. The WHO as an institution has tried to deal with these tensions in areas such as tobacco control. We've seen this in access to medicines, but it hasn't always been successful because they're inherent in the complexity of regimes. The IHR of 2005 for me is a really good point, is a really good case in point of articulating this complexity in regimes. The IHR of 2005 are governing regulations that are ratified by 194 states in order to govern the spread of infectious diseases such as Ebola and COVID. But we see that they try to spell out the duties and responsibilities of public and private actors in detailing health documentation applicable to international trade and traffic, and in providing control measures for travelers on the basis of a science risk assessment, proportionality, and respect for human rights. However, this relies primarily on the state parties involved and the increased use of formal and informal networks of law in order to create compliance on behalf of non-state actors, so which are the private entities in this case. So Quinn and Switzer have this brilliant article that they wrote post-Ebola that looked, for instance, at the aviation industry and the way in which states had tried to kind of counter those public and private mechanisms in order to keep the airline industry functional within this crisis. In the same way, we see immense pressure during the current COVID crisis to keep borders open. And this might be because of pragmatic reasons. So it might be because you want to ensure that you have a supply of personal protective equipment, you want to have a supply of diagnostics, but ultimately I think there's also a strong desire to keep trade going so that economies do not collapse. And so you see that there's a large range of non-state and therefore private actors that are involved within this public health regime in a way that is problematic because the state regime, the public health regime is always really primarily focused on states. So in this presentation, I'm going to focus primarily on the IHR and public health surveillance. And I'm really analyzing the way in which we see the increased rise of non-state actors and private actors in the field of public health surveillance. Under the IHR in 2005, one of the major aims of surveillance is to control infectious diseases. And so surveillance is a mechanism by which we can see which countries have the disease and therefore work together collectively, as Eyal pointed out in his paper, in order to stop the spread of infectious diseases. So public health surveillance is the systematic collection of and storage, usage and dissemination of public information. This is commonly now in electronic form in order to identify outbreaks and mitigate the spread of disease. So you have those two things in tandem. So you have identification and mitigation, which will really bring us to how private actors are increasingly getting involved. So during pandemics such as COVID-19, public health surveillance is considered critical to averting and containing epidemics. And it also provides us with a scientific and factual database to inform decision making. And this goes back to Lisa's work on how then we allocate resources. And we can't do this allocation fairly if we do not have good epidemiological data, which is usually through public health surveillance. So the data collected provides basic infrastructure in order to effect many of the common goods of community health. But it's also problematic data because it has commonly identifiable details that might be sensitive to individuals. So this may involve personal details around people's mental health, people's lifestyle, sexual orientation, family history, and increasingly the use of genetic data using public health surveillance. So public health surveillance is not new. There have been early attempts to ensure compulsory reporting of infectious diseases, says earlier 1741, with the passing of legislation in the Americas, which required the reporting of smallpox, yellow fever, and cholera. We've had kind of ideas around public health surveillance, but my argument in this paper is that public health surveillance has changed, both within the current COVID-19 crisis, both because we do not understand the crisis very well. So this is a disease that we have no traction. It's not cholera or any of these other diseases that we know how to treat. And so the scale of this pandemic has deepened the imperative for policymakers to expand traditional public health mechanisms of surveillance, which were largely by manual contact tracing, to include new technologies using GPS, cell phone apps, facial recognition, and artificial intelligence. So a lot of these new digital tools are not in the control of the state, but they're in the hands of private actors. So for instance, I'll convincingly refer to the role of AI startup Blue Dot in his conclusion, which detected the outbreak in Wuhan before the Chinese population was officially appraised of the threat. The Chinese technology giant Alibaba has developed an AI system that can detect coronavirus in CT scans with 96% accuracy. And we also see in the USA that Jared Kushner is spearheading a collaboration between the Department of Health and Human Services and technology firms in order to establish a public health surveillance system that is called JOIN. So these new surveillance technologies considerably ratchet up longer standing tensions in public health between individual rights and collective interests, because they lead to reduced privacy online with the use of big data in policy making, but also the increased fears about the monetization of this online data. The fact that these surveillance mechanisms are also controlled by private entities such as Google and Apple, who provide a lot of technology for this increased surveillance, leads to fears that public health measures are being driven largely by surveillance, so that in some ways the rationale for public health has changed beyond infectious diseases on themselves, but has now moved to the private actors who are coordinating a huge part of this surveillance. And that is problematic when you think about the public international law project. So these actors have a key role and vested interest that is problematic in this because of elements of public gain. And I think that that's one of the things that's worth thinking about. So the things that I'd like to consider really briefly is what are the public international law implications of mass digital surveillance by private actors in the name of public health. So here I will think about human rights and think about some of the issues that Lisa raised in her excellent presentation on the right to health, But also I think that there are other areas of international law and sovereignty implications that we should be thinking about in terms of how the state is going to interact with this public health surveillance. From a global health law perspective, the arguments that have been now made by Ferretti and others in Science recently, that because COVID spreads really rapidly, manual contract tracing or manual surveillance programs are totally inadequate. However, on the other hand, there are legitimate fears about the increase of public health surveillance and the impact that it might have on privacy violations, such as individuals being barred from movement because they're being surveilled through their mobile phones, through geofencing techniques. So techniques like data mining, which are used increasingly for public health surveillance through looking through large trolls of things like Facebook and WhatsApp chats and stuff on the internet, are really problematic because they don't only just collect public health data, but are also collecting a large amount of other individual data from citizens. So there have been some attempts to clarify these duties, so rights to privacy and others within, for instance, the European context. So the EU Data Protection Board recently made recommendations about increased anonymization of data. However, in some instances, this is just not going to be possible. And I think there are lots of scientists out there who've said there's nothing like anonymized data under these circumstances, and this data can always be de-anonymized. And so the EU Protection Board has recommended that in instances where it's not possible, all this data must fulfill the criteria for necessity, proportionality, and appropriateness, and must be subject to appropriate judicial remedies. Article 43 of the IHR also states that measures that impose restrictions must be supported by science, respect human rights, and be proportionate to the risks. However, it's quite complex to identify what the risks are under these circumstances, because a lot of this technology is really new, and so we do not know the risks that people are taking. Also, it's really hard to know whether the science of contact tracing and digital tracing is accurate. So David Schroeder and others in the BMG this week talk quite persuasively about manual contact tracing still being the most appropriate thing to do within communities. And so that makes it really increasingly complex. And so even if we agreed that actually digital tracing was perfectly appropriate, it was necessary, and actually it was proportional, what do we do when there are violations? In many of these instances, the state is merely a minor actor in the way in which public health surveillance is moving. And so when there are violations, who is the duty bearer? So under these circumstances. So I think Professor Shane Dursey's presentation on business and human rights here might be really helpful in terms of thinking about ongoing violations by non-state actors, especially businesses in this vein. But I think that these are questions worth thinking about and will become much more problematic when we think about low and middle income countries, where actually these corporations might be significantly much more powerful than states. The second thing that we need to think about is that the reliance on third parties, and in this case is private actors, to create tools that store and create mass surveillance data might leave individuals and groups particularly vulnerable. And private companies do not have, private digital companies do not have a very good track record in this area. So we've seen allegations of election fixing, we've seen allegations of data on Facebook. And I think that that is really worth thinking about from a public international law point of view. So for instance, in the UK, there are serious concerns about Circle and Amazon Web, who are providing the storage data for public health surveillance systems. Given that this data is going to be held for 20 years, it's unclear whether these companies are going to be allowed to privately benefit from the use of this data. My concerns also go to Eyal's presentation, because in his presentation, these private companies are then kind of presumed to be the saviors of the global health law project. And so he really thinks about the role of insurers increasing in some ways the data that they have on individuals. But given what we saw, for instance, during the Ebola crisis, when children and pregnant women were excluded from Ebola vaccines on the basis of risk, is it really a good idea to think about them becoming integral parts to public health law in this way? My last point that I'm going to make is that there's a much more fundamental question here than the privatization of public international law. And I'm really thinking about how this is going to change the concept of sovereignty and states in terms of thinking about these collaborations between states and private companies. For instance, given that private actors are going to be quite integral to this process, should we see a possibility under the IHR of private actors having a duty to make notifications under the new system? Will they need state consent under those circumstances? And if they won't need state consent, how will that have changed the public international law system in the way in which we know it? Will it have become essentially a private international law project in the way in which we think not only about surveillance, but also the way in which we think about the governing of infectious diseases more generally? So thanks very much. I'll stop there.
Thank you so much, Sharifah, for that excellent and very captivating discussion around health surveillance. Not only does it link back to Eyal's presentation, but very much will link into Benedict Kingsbury's presentation around data infrastructures. But before we go there, I am absolutely delighted to welcome Professor Christopher McCrudden, who will be investigating the international law requirements surrounding inquiries into deaths arising out of the pandemic and the relationship between learning from accountability and liability in that context. So Professor Christopher McCrudden is a Professor of Human Rights and Equality Law at Queen's University Belfast School of Law, as well as the L. Bates Leah Global Professor of Law at the University of Michigan Law School, and is an expert in public international and international human rights law, amongst other areas. So delighted to hand the floor over to you, Chris.
Thanks, Donna, and thanks very much for including me. I've been listening intently to the discussion so far. I hope I can contribute something. I'd like to share my screen, and let me just see whether I'm going to be able to do that.
Yeah, it's working.
Great. So what I need to do then is to be able to play it from the start. Is that okay?
Perfect.
Thanks. So what I'm particularly interested in is the interface of international law and domestic policymaking in this kind of context. And the particular issue that I wanted to focus on in the short time today is this question of the Article 2 investigative duty under the European Convention on Human Rights. But I want to focus it also in the context of the international law provisions more generally, and I'll raise that issue again at the end. But it'll be primarily on the Article 2 ECHR investigative duty. And the issue arises because of the debate as to whether a public inquiry should be held into the UK government's handling of aspects of the pandemic. I don't need to go into too much detail, I think, to justify the conclusion that it has been controversial in terms of the UK government handling, and that allegations have been made of ignoring previous reports, for example, of inadequate provision of safety equipment, of inadequate procurement, etc., etc. So there's potentially quite a lot to investigate. And the question I'm interested in is, how does that debate interact with or interrelate with the Article 2 investigative duty under the Convention. So I'm now trying to move it, and the question is whether I can. Yes, thank you. So there's a particularly heated debate in the UK at the moment in government and scientific circles about a possible inquiry. Scotland has jumped the gun, as it were, and announced that it will hold a public inquiry at some point. Westminster essentially has resisted the notion of a public inquiry, at least not yet, though every interview that politicians seem to do these days seems to conclude with, well, that may be an issue for any inquiry. There is a limited parliamentary inquiry set up, but it is, as I said, limited. There's also going to be litigation. There's already litigation, but it tends to be sporadic and focused on a specific issue rather than the overall policy. And for the sake of completeness, obviously deaths would normally be investigated through the system of inquests, but it's unclear how many inquests of COVID-19 deaths will actually take place because legislation has been introduced that seems to limit the inquest procedure. And in any event, even in those cases in which inquests do take place, they're often an unsuitable forum where government policy is being investigated, government policy that arguably has contributed to thousands of deaths as the object of the inquiry. So the question then essentially is why an inquiry might be able better to deal with, for example, the problems that inquests are not able to deal with. And there's a very useful blog by Paul Bowen on UK constitutional law that investigates this. And he suggests that there are essentially three problems with inquests that inquiries might be able to better deal with. One is that Article 2 issues involving high-level policy considerations, such as the procurement of suitable protective equipment, are not really suitable for determination by an inquest. Secondly, that an inquest can only examine single deaths or multiple fatalities arising from a single incident, but generally is unsuitable for dealing with systemic issues involving a large number of separate deaths with common features. And finally, that an inquest can't determine Article 2 issues involving serious illness or injury, which don't cause death, of which there'll be obviously many more in this context as well. So for these reasons, litigation and inquests seem to be likely to be an unsuitable mechanism for dealing with the broad policy issues that are being raised. So the debate then circles around a public inquiry, and such an inquiry does seem inevitable at some stage. But what type of inquiry? And the current debate revolves around three different types of investigation. What's sometimes called a lessons learning investigation. That is, what can we learn? What lessons can we learn from the current, some would say, mishandling by government of the current pandemic? So what lessons can we learn from that? So it's forward-looking. Accountability mechanisms, that is, who's been responsible for these problems that have arisen. And thirdly, liability. And by liability, I mean, and is generally meant, more limited notions of whether there's been specific legal liability, negligence, criminal liability. So at the moment, from the scientific, medical, and policy establishment, there's a heavy emphasis being placed on a lessons learning inquiry because of the urgency of learning lessons in order to inform policy for the next wave of the pandemic and or the next pandemic. And there's been a recent, quite influential report from a group led by Christoph Meyer at King's College London, which has again reiterated the importance of a lessons learning inquiry well before any accountability inquiry. So that has contributed, I think, to a mood within the medical establishment for a lessons learning inquiry to the exclusion of anything else, at least in the short term. And that letter has been published in the British Medical Journal, but there have been similar editorials in the Lancet and so on. So the question then arises, what's the role of human rights standards in this debate? And the answer is that outside the usual legal blogs and a few of the human rights NGOs, notably a recent statement from Amnesty International, human rights standards for investigating deaths are seldom mentioned. And there seem to be various reasons why this is not percolated into the policy establishment in London. Interesting how little it has percolated, given the emphasis in other contexts of the importance of an Article 2 investigation standard being met, particularly in terms of deaths in Iraq of people there under the jurisdiction of the UK. So why the lack of penetration? And there seem to be three possible reasons. It's really quite unclear, but I'm suggesting three possible reasons. One is a general underlying hostility to law. Anybody who's participated as a lawyer in mixed policy company knows the degree of hostility that there is often to law and to lawyers. Second, there's often an assumption that legal standards are about determining private and criminal law personal liability, and surprisingly little knowledge of what might be called public law understandings of accountability as contributing to better policy making, as contributing to better governance arrangements, and it's future oriented. But there may be another reason, and it's that I want to try to investigate in the next couple of minutes. It may be because the human rights standards don't actually contribute much to the debate. And of course, if that's the case, then that says something important, I think, about international law, international human rights standards, European standards, and their interrelationship with policy decision making. So what is the investigative duty regarding arising from Article 2 in this context? And part of the problem in determining what the duty consists of is that much of the European Court of Human Rights jurisprudence derives from police or military actions leading to deaths, rather than in the context of pandemics. Fortunately, we haven't had many. And they have tended not to give rise to this kind of sustained concern. So there are obviously important cases in the court dealing with deaths in hospital, which are more immediately relevant, but there are relatively few of those. So what emerges from the jurisprudence that we do have, and what emerges is, I think, two minimum conditions. First, that an investigation should be carried out where there is at least good evidence, probability that there may be a substantive violation of Article 2 itself on the right to life. And that investigation must be effective. That's an obligation of result, not of result, but of means. So an effective investigation. And secondly, that it must meet certain procedural requirements. But the problem is, what does that actually mean in practice? Because saying an investigation must be effective and that it has to be procedurally okay, it doesn't really cut the mustard if you're sitting in a policy discussion in Whitehall, because you're immediately going to be pressed as to what exactly that means. And there has been some discussion about that going on, particularly in the blogs. And again, there's the useful blog by Paul Bowen that I'll be borrowing from. So what does an effective investigation mean? And it seems to involve a number of elements. That the full facts should be brought to light, that the investigation should establish whether there's been a breach of the state's positive duties, that it should identify those responsible, that it should enable lessons to be learned to prevent similar deaths in the future, and I'll come back to that one in a minute, that it should alleviate public concern, that it should provide the bereaved with an opportunity to understand what happened, how their relative died. So that's effectiveness. In terms of the procedural requirement, it seems that the requirements are that the investigation should be commenced by the state, and I'll come back to that also, that it should be conducted by an independent body or individual, again, come back to that it should be established with diligence and promptness, and that it should have effective involvement of a next of kin, so family should be represented, for example. So some of the issues that arise from this then, and I'm intentionally going to be pretty brief, as Donna asked us to be as brief as possible. Some of the issues arising from this are quite challenging, quite interesting. So the points that I just made in terms of the, particularly the procedural requirements, in terms of the procedural legitimacy of the system of investigation and whether it meets the Article 2 obligations, that challenges the growing view in the scientific and policy community in the UK that an accountability inquiry will undermine or may undermine a lessons learning inquiry. Now, this, for lawyers, this may seem a strange proposition to make, but it has really caught hold in the scientific and policy community. That the buzz phrase is, we want a lessons learning inquiry, not an accountability inquiry, not least because an accountability inquiry may get in the way of a lessons learning inquiry. So we need to be pretty firm if we're going to have a human rights standard applied here, that an accountability inquiry does not necessarily undermine lessons learning inquiry. But we need also to be on firm ground that it's true that it doesn't. Second, the Article 2 obligation requires, as I've said, a state-initiated investigation, not one initiated by others. And again, some of the proposals that are circulating around in London at the moment are suggesting that an inquiry should be set up by some independent body, not a state body, but some independent body, such as the Wellcome Foundation or the Royal Society or whatever. So the Article 2 obligation seems to squelch that, because the inquiry, it seems, should be a state-initiated investigation. Thirdly, the Article 2 obligation requires an independent investigation. But there's a real issue arising about who's independent, who could actually be appointed to such an inquiry in the current context. And the reason for that is that anybody that seems to know anything about it also seems to have been involved in some way. Whether as a member of various scientific advisory bodies to government, which themselves, the famous SAGE committee, which itself would be a subject for investigation in such an inquiry. A lot of the independent bodies, a lot of Wellcome Foundation, for example, the Royal Society I mentioned, are represented on SAGE. So where do you actually get an independent investigation team? And then thirdly, the requirement for promptness in initiating an investigation. But there's no requirement, it seems, under Article 2 for how long the investigation can go on for. It should be prompt in being initiated, but that didn't prevent, for example, the inquiry into Bloody Sunday, into the killings of civilians in Derry, for going on for over 12 years. Or the Iraq inquiry going on for, I think, 6 or 7 years. So the problem that seems to be arising is that the more thorough the inquiry, and this is an obvious and old problem, the more thorough the inquiry, the longer it's going to take. The longer it takes, the less likely it is that it's going to contribute to future policy making in a quick and clear way. So, conclusion then. What I'm suggesting, I think, is that more work needs to be done to unpack the implications of Article 2 for present policy decisions. In other words, that international law now has the opportunity to be mainstreamed in real time. But that requires ex ante advice. It requires the unpacking of the requirements of Article 2 now, rather than relying on the human rights standards to contest what's already been done ex post. Clearly, most of the cases that have arisen are where the Court of Human Rights has been investigating how inadequate an investigation has been, like in the inquiry and in the Iraq context, rather than setting out ahead of time what needs to be done. And the problem for government is knowing now what the requirements are going to be with regard to Article 2 for this particular policy problem. And here, I think we have a potential role for the Council of Europe or for the Venice Commission. Where is the Venice Commission when you need it most? And the other question that arises, and this really is a question for the group, is whether there are better standards, more fleshed out standards available in other areas of human rights or international law that can supplement and flesh out the ECHR standards. So I apologize both for being brief, but also for being relatively practical and not theoretical. This is an important problem that is going to certainly affect the state of British, but I suspect of other countries' policies in the next few years. We need to get it right. And the question is whether international law, international human rights standards in the shape of the ECHR can contribute to that, or whether it has to sit on the sidelines. I hope it's the former rather than the latter. Thanks.
Thank you so much, Christopher. That was really interesting. Thanks for that stimulating and very important presentation on inquiries into deaths during the pandemic. Hopefully we'll come back to that issue in the questions and answers session, but we're just a little bit behind schedule. So without further ado, I'd like to introduce our next speaker, Professor Benedict Kingsbury, who was also a professor of mine in NYU in 2008. Delighted to see you again. So Professor Kingsbury is the Murry and Ida Becker Professor of Law, as well as the Vice Dean of the school and the Director of the Institute for International Law and Justice at New York University School of Law, and will look at international data and information as well as issues of law and infrastructure. And just to note, other speakers, you're very welcome to turn on your videos if you like. But without further ado, I'll hand the floor over to you, Benedict. Thank you.
Well, thanks, Donna. It's really nice to see everyone. Well, this talk is really from work jointly with Angelina Fisher and Thomas Strantz, both here at NYU. It's a combination of two projects that we've had going for quite a long time and trying to think about this in relation to the epidemic questions. So one of those is on global data law, this Guarini Global Law and Tech initiative we have. We're trying to see if we can see the shaping of a field of global data law emerging. And the other one is on infrastructure, and in particular, the idea that infrastructure often operates as regulation. And I gave a short talk at Cambridge about that, which is published, which tries to sketch out a few of the basic ideas of infrastructure as regulation from an international law standpoint. That includes physical infrastructure like the Panama Canal, and informational like indicators, and also digital infrastructure. So bring those two together is what we try to do in this, and the title is Pandemic Data Law and its Infrastructure. I'm only going to sketch a tiny bit of the ideas in this now and give an example or two. So the message of this, at least from where we are so far, and it's very rushed work we've been doing on it, is that to think about international law in relation to health situations like this pandemic depends on data. And data coming into international law really depends on the infrastructure. And the infrastructure has major effects on how data is defined, what gets collected, how data moves along track, where it gets blocked, how it's analyzed, how data analytics is going to work, how it's operationalized, turned into forms that people can internalize in policy, legal debates, and act on maybe, how it gets publicized, how it mobilizes opinion or not, and probably most fundamentally, what meanings emerge from it, how they're given, and what meanings are excluded or shut out or distorted in that set of processes. I put that, I hope, in neutral terms, because the fact that something's data, it's read that way, it doesn't mean it's correct, it doesn't mean it's politically attractive, etc. So it's meant to cover all of those things. But of course, that means that some of the core politics are going to be fought out in relation to data. It follows, I think, from pretty standard thinking in infrastructure studies that infrastructures are not neutral. They're a shaping force. I'll come back to that just in a moment. And not surprisingly, that the existing pandemic disease data infrastructures don't align very closely with the standard WHO information flow model. And Sharifah's already brought out some of these points about that, I think. Well, data infrastructures have a shaping or even determining effect, I think, on what it means to comply or not comply with some norms, including some norms about notification of infectious diseases. The effective data infrastructures can be quite important for establishing accountability or even legal responsibility in the way McCrudden was just talking about. I think data infrastructures also have really an important effect on what's doable, what can be done, and what's really not doable, because there isn't either the information turned into knowledge or there isn't really the public support, which data can sometimes be relevant to mobilizing or blocking. And that overlaps with the point that the data infrastructures really have a big effect on what gets to be deeply understood and on what never gets to be known or is only very belatedly known. Again, this connects, I think, with this inquiries question. And the question of what rules are really effective in the space, what policies, what norms, what institutions, and what other kind of worthy sounding legal rules or institutions or even other infrastructures never become significant. It's really connected heavily with this whole integration of law, data, infrastructure seen together. So those are some of the reasons I think this field is important. It's not, the nitty-gritty of infrastructure is not very fashionable amongst lawyers, but I think it's severely understudied and much more important than it is in the ordinary work, and that's why I'm at least trying to mention it here. So turning to the WHO, this is their own schematic of their standard information flow model for communicable diseases of all sorts. And the way that's written, it starts there at the top. The peripheral level means the very local, the village, the hospital, the site where some information is being collected about a possible disease, syndrome, diagnostics, testing, whatever it might be. The idea is that then funnels up to a higher level, say the county, province, state, eventually to something the central government has, the CDC or whatever it might be in different countries, and from there on to the WHO, sometimes through the regional WHO bodies, connected bodies, and sometimes directly, but that's where it ends up. So it has a pretty familiar international law type structure, jurisdictional, territorial, and of course tied to the organization of government. So that's the core architecture, but in fact, there are lots of other architectures going on for data infrastructures. The WHO itself oversees one of them, an important one, which is the Global Influenza Surveillance and Response System. And that has a whole set of national influenza centers. So that follows that part of the structure. It has some specialized WHO collaborating centers which are localized but play a sort of global role. It has the essential regulatory laboratories, which its key things like deciding what the thing is, giving it a name and saying this is it and this is not it, and this is distinguished, etc. The reference labs for testing, etc. The more advanced facilities which a lot of countries do not have. So that whole system is developed for influenza viruses of many sorts, and it's been extended to the coronavirus, COVID-19, for surveillance and reporting. And often the same labs for influenza are doing this. But it's not its original design, so it's been a rapid on-the-fly extension. But then it's going to be very relevant to COVID data infrastructure to see what the influenza one is. And of course, the politics and circumstances of influenza, many types, have been very different from the current one. So not surprisingly, there could be questions about the alignment of that infrastructure with what people now are interested in, blocking, etc. That current structure of influenza infrastructure had an important inflection, which produced its current version, which is the controversy which Indonesia precipitated, although other countries shared this view very much of theirs, when in 2006-2007, during what was feared to be quite a dangerous situation of H5N1 avian flu coming from poultry, Indonesia, having earlier shared samples, biological samples, started to resent the development of the granting of a patent to a company in Australia, the company hoped to make a vaccine for the H5N1, but Indonesia was concerned that they hadn't approved this and been asked even about it, and didn't have any rights in relation to that vaccine, and particularly they were concerned that they wouldn't be able to afford to buy it. So that led to a significant discussion about the relationship between access to this kind of information and the benefits, the flow back of benefits. And the PIP framework has this access benefit exchange structure about it, at least in theory. There are supposed to be standard materials transfer agreements for the movement of samples, and that those do set some obligations on the recipients. But it seems really, in contractual terms anyway, there's no basis there to see a major benefit flow to the country where the sample came from, or to developing countries in general. There's an idea there, but it's really not strong in those terms. So overall, it's not quite open access, but it's more in that direction. And in any case, that only applies to pandemic influenza, not to the ordinary influenza, not to the complex processes which produce the annual flu shot, which involve a collection of lots and lots of samples and study of them, and discussion of which ones are likely to be the most virulent and become the dominant ones in order to prepare that vaccine. So this doesn't apply to that, and it doesn't apply to non-influenza pathogens like Ebola, SARS, or of course COVID-19. How then is genetic protein or protein sequence information actually shared? Well, there's lots to say on this. One of the standard ways is GenBank, which was established in 1979 at the Los Alamos National Lab at the US, later shifted over to where it is now, the US National Institute of Health. GenBank, a system, it enables people to send in genomic information on viruses, other things, so protein information, various other things, metagenomics and so forth, to send it in, and it enables distribution of that data, so it's very important. It doesn't impose any restrictions on how that data can be used. Distribution doesn't impose any controls on access to that database. So it's very much an open science idea. And the first sequencing of the COVID-19 virus was supplied to GenBank, and that's how it was distributed. GenBank is accompanied by a whole structure of sequence reading systems, faster than others, and also each lot of material deposited there gets an accession number, which enables reference in the scientific literature and other publications and distinguishing between different ones. So it's very important. It's really a key tag in the whole of the system. So that's GenBank, originating in the US government and still run there, although run in the context mainly of scientists making decisions, so far anyway. So that's the web portal of GenBank. That's what you see. It's what you use to upload things, access things, etc. Now, a second global database for genetic sequences and associated data is the GSAID one. This was launched as an alternative to the very open public domain data sharing model that GenBank has, launched in 2008, and it was connected to the Indonesia issues I just mentioned. It's run directly by a German non-profit set up for this purpose, but with support of the governments of Germany, Singapore, the US, and quite a lot of others. So the US government is a supporter of this thing, but it does require users to make an agreement when they're going to be part of this. You can only get data from it if you register, and to do that you have to make this agreement, which requires you to acknowledge the origin of the materials you're using, including if you make publications, and to make some effort to collaborate with them, and that you can't share that data with people who haven't made the same commitment by joining it. So it has some restrictions, and it certainly has the aim of providing credit, which can be very important for scientists for the original work of finding these things. So those are the two well-established global databases for these. What kind of data is it which is coming in these bases? Well, here's the first sequencing of the COVID-19. And as you see, it's the familiar notation, RNA here. It goes on and on. And of course, I just mentioned this because always has to keep in mind that behind any of these structures, there's a whole lot of other infrastructures and conventions. And in this case, it's the one for rendering material in a genome into, in this case, standard alphabet sequencing, so that other people can know what it is. But it's vital that everyone understands that convention. And so behind all of this, there's that whole structure. And this is just a reminder that we are doing this everywhere. This is the ASCII system in which we turn A, B, C, D into binary in order for it to come up and go through a computer system and someone else to be able to see the same thing. So there's lots and lots of these things, and many times they're just accepted without much thought, but behind them are choices, and every now and again something becomes controversial in those, or some of the core interests which were dominant when they were made, no longer core, and other people have different interests, and sometimes these can be rethought. But unsettling conventions like that, especially deeply established and widely shared ones, is very challenging, very costly often, and it's a reminder that infrastructural time is different from legal time and different from political time. So politics and interest may change, but the infrastructure simply carries on. If you think of the Panama Canal lumbering through there 100 years later, we would have probably supported that now in terms of what it does to local people's water rights. When there's a drought, the water goes into the canal and not into their taps. But there it is. That determines really the use of water there, and the similar kind of thing with a lot of these infrastructures. So what to do with the genetic information? Well, I think it's all very familiar already, all the discussions about trying to show origins of things and that kind of highly politicized controversy, but also to try to work out which animal reservoirs it came from. Zoonotic comparison here of that one with bat viruses that were known, with the earlier SARS one, etc. So but this is fundamental to lots and lots of things, as well as most obviously testing, diagnosis issues, and vaccine development and therapeutic development issues. So it's fundamental, this infrastructure, to those things. And I've tried to give some indication here of at least what have been some of the political stakes, the winners and losers, the power structures which are built into particular infrastructures that develop in the way they last. Well, I've mentioned here this part of infrastructure, but I think it's also important when we think of data and even data infrastructure to think of the interfaces, the way in which the data is turned into information or knowledge. And one element of that, and there's many elements, is visualizations. So we all see the standard coronavirus image and probably form rather delusional views of the virus from what we usually see. I haven't put that here, I put up this one. This is, of course, very fundamental in ordinary genetics work. This is just a reminder, though, that the question of visualization and conventions of visualization, which are oddly very thinly established, very few legal standards, or even, as far as we've found so far, kind of highly formalized international standards on visualizations, but how important they are to how people come to understand the thing and interpret it, including, I think, in particular, people high in policy space and politics. So just to move towards concluding, but to carry that one step forward, it's probably helpful to think about all the dashboards people use for thinking about epidemic data at the moment. And many people look at different ones, in many countries, different ones are dominant in the media. A pretty standard one in some places is the Johns Hopkins one, which make very quickly. So it's done at private and a university, using originally data from these places, the US CDC, the European CDC, the two in China, which are fairly have comparable kind of roles, the WHO. Gradually, of course, now it uses many more sources. The WHO dashboard, this is where they were, I think, on 11th of February. See a view of the COVID then in those places in the world. The numbers, the number of cases there are rather limited. Number of confirmed cases at that time. Here's by the end of April, 3 million, and the world map of this looks different. But the sensibility of where it is, where it's going, what the scaling is, the choice of using cumulative data rather than daily only, all the visualizations can make a difference. There's much more, I think, to say going down that track. And I just wanted to mention to finish that although we tend to talk heavily about the human elements of this, that there's a strong connection with animal health here. And we're now working as best we can to understand what goes on in the World Animal Health Organization, the FAO, and this combined structure that they use with the WHO, particularly relevant to zoonotic diseases, where many of the same issues arise, but the politics around animal health and animal health data are not the same as the politics around human epidemic data. So with that, I'll finish. Thanks.
Thank you so much for bringing your expertise in mega regulation and global administrative law and data infrastructures to this discussion. That was so interesting, and hopefully we can come back to that in the questions and answers. Really thought-provoking points there, Benedict, so thank you immensely. And without further ado, I'll move on to our next speaker, who is Judge Howard Morris, and he is at the International Criminal Court based in The Hague. So I met Howard for the first time in 2014 when I was working over there. It was a great pleasure to get to know you and to stay in touch, and we are so privileged to have you here today. So Judge Morrison is in the Appeals Division of the ICC, formerly a judge of the ICTY, and today is going to talk about the practical impact of COVID on work in the appeals chambers and other concurrent issues. So I'll hand over to you, Howard. Thank you.
Well, thanks, Dalla. Are you getting me? Okay. Well, it is a very severely practical issue as far as the ICC is concerned. The effect has been dramatic. When the sort of pandemic was first announced, I'm pretty sure we didn't take it very seriously. In common with a lot of other people. And then when the effects became more obvious, the rapidity with which it could spread and the consequences for a significant number of people, we had to do something about it. And the court have effectively closed its doors and emptied its rooms, and everybody was working remotely from home, and a lot of people still are. The real impact was on the trial and pre-trial cases that were going on at the time, because there was no mechanism then to turn a live hearing into a virtual hearing overnight. And that's now been put into place. So pre-trial and trial hearings, partially live, partially virtual, can commence again. And in the appeals chamber, we had a virtual hearing in Bagbo, with a significant number of people actually in the court who wanted to be there with social distancing. So it's working. Inevitably, it has slowed the business of the court down. That is that's from my own personal perspective, that's quite significant, because I'm at the moment president of the Appeals Division. I've got 2 major appeals on Bagbo and Ntaganda, and I've got to finish them before the expiration of my mandate in March 21. So it's a 7-day week at the moment. But the real problem has been in the appeals division. We work very much in a spontaneous way, face to face. It's an open door policy. Legal staff come in, speak to the judges come in and speak to each other. Ideas are swapped, research discoveries are made and shared. And that has slowed down significantly, because while you can do it by email and you can do it by Zoom meetings, and we do, we've lost that facility just to walk 10 meters up the corridor and speak to someone when an idea has jumped into your head, and vice versa. So the spontaneity has rather gone out of it. It will come back, of that I'm sure, but slowly. We're going to have to learn to live not only with the resurgence of this, the next phase of this pandemic, which everybody anticipates may happen over the winter, but of course the next pandemic as well. But we've learned valuable lessons, and we've put in structures for much more sophisticated virtual hearings than we had before. Because one of the practical problems is that there's a lot of international movement in and out of the ICC, people going to, for instance, Congo, Central African Republic, coming back, other countries where there are investigations, field officers coming and going, investigators coming and going, lawyers coming and going, and all of that has pretty much stopped. So it's not just slowed the immediate work down, it's put a bit of a brake on future work, and it's going to take some time to play catch up on that. So those are the real practical effects. It's the slowing down the interaction. And we've got to look to the future. A vaccine may help, I'm sure it will, but that could be a year in the making, depending on who you believe, who you listen to. And many of our interlocutors are not in Europe. Some of them have very limited access to reliable Wi-Fi, especially in the Congo and the Central African Republic. I mean, that's a fairly standard problem regardless of COVID, but it's amplified it. And the implications from a human rights point of view for timely procedures and swift justice are obviously affected. So far, the delays have not been the cause for, as it were, official complaint or submissions. So I think most people are taking a realistic view of the effects of the pandemic, but it is nevertheless, it's frustrating for the staff as it is for the people who are locked up in the detention centres or in otherwise confined. So the ICC, we work in a large enclosed building where people interact and come into close contact. We have many external interlocutors, and they come in as well. And so we have got to get used to a different system of working and try and maintain as much interaction with those people who need that interaction, not least the defendants and the victims of allegations. We, of course, no more than most didn't expect a pandemic of this nature. When we think about security at the ICC, we're not thinking about security from viruses. We're thinking about potential attacks, physical rather than verbal, and the safety of staff, because people work in dangerous circumstances, and the court has many enemies, some more vocal than others. But it's been a steep learning curve, and we'll be better prepared for the future and the next time. Lisa talked about the other enemies, as it were, of the court, apart from the virus is, of course, quite literally a virulent attack, but we suffer virulent attacks, verbal as well as political. Most of the verbal attacks are political. Unfortunately, the truth of the matter is that a lot of people express a desire to cooperate with international law, and the lifeblood of the ICC is international cooperation. We have no police force. we have no Chapter 7 powers, unlike the ad hoc tribunals had. So we are 100% dependent upon international cooperation. And what we've seen in a number of countries, in a number of places, that people are prepared to cooperate right up to the moment that they themselves or people they regard as their friends are being investigated, at which point that not only does the cooperation stop, but the hostility starts. This is human nature writ large. We're not surprised by it, we're disappointed by it. And you have to do your best to work around it by explaining to people who will listen that the ICC may be all that stands between people and the horrors of impunity. And we've seen that work out. And by the way, I'm going to do a swift plug for a book. Honestly, I'm not getting commission from this. I read East West Street by Philippe Sands, and I've just finished reading The Rat Line, and I thoroughly recommend both to anybody. I dropped an email to Philippe, having read The Rat Line, because it so much validates what I've been trying to do for the last 20 odd years. Excellent books, and sets out international law in a different perspective. We look to the future, and one thing that the pandemic has made me think about is how we're going to get away from, not that we need to, but I think we will, the classic offences which we deal with in international criminal and humanitarian law: crimes against humanity, genocide, which is of course a crime against humanity but a standalone one, war crimes, and the crime of aggression. Now, we haven't had anything yet on the crime of aggression, and we may have difficulties with that. This is my perspective. I don't speak for anybody else. Crime, we deal with individual criminal responsibility, and aggression is more likely to be state actors rather than individual actors. And unless you have an absolute and complete dictator, and some places do, then it may be difficult. But I'm thinking of other things at the moment. I've been advocating when speaking to students that we're going to have to expand international criminal law and humanitarian law, for that matter, into environmental matters. The category of crimes against humanity is not closed. And if an environmental event occurs, often by human hand, that causes enough damage, distress, death or destruction to a significant number of people, then why can't that be elevated into a crime against humanity? And I accept that we're going to have to change the thinking and architecture of international law to accompany that beyond where it is, although the prosecutor has already said that that's something she's looking at, and we already have destruction of cultural monuments and things of that nature. But we're going to have to go further ahead with that. And then that made me think, well, how would this relate to a viral attack? I'm not talking about cyberspace, I'm talking about biology. And I suppose that if it was the case that somebody released a virus negligently, there's no problem if they release a virus deliberately. That's biological and chemical warfare. That's readily understood and dealt with. But what happens if there's an escape of a biological agent which causes huge damage to humanity on a scale that could be measured as a crime against humanity, or even bigger than some we've seen? Is there a mechanism, is there an architecture by which one would extrapolate from negligence into some sort of control of the crime theory, some sort of complicity, some sort of criminal negligence, to put it on a broader theme? And I think the answer to that is probably yes. And people are always looking for new PhD topics. And I always say to students these days, if you're thinking of a PhD topic, you might want to think of the expansion of international criminal law, humanitarian law into environmental disasters and breaches of environmental law, the expansion of liability for international corporate offences. So we're not just dealing with reparations, we're sending CEOs to prison, which might sharpen up their minds a bit. And then COVID-19 appeared on the horizon. It's easy to think of these things. It's much more difficult to construct the architecture and the international cooperation, which is vital to expand or change international law effectively. But I think these are things we've all got to think about. At the moment, we're coping. I think we're coping pretty well. We hope that in the autumn we'll get back to some more real hearings as opposed to virtual hearings. And we'll certainly be in court to deliver judgments rather than doing it simply over the web, which I don't think is very satisfactory. But I'm very grateful for all the presentations that have gone before, because they've dealt with stuff that I haven't thought about. And now I'm going to have to. So that's all been very interesting. But I look forward to any questions and answers.
Thank you very much for that, Howard. It's excellent to hear about the practical implications of the pandemic on the administration of justice. And we're really honoured to have you here today. So thank you very much. Our final speaker is Professor Juan Mendez. And I encountered Juan for the first time in New York as president of the International Centre for Transitional Justice. Soon thereafter, he went on to become UN Special Rapporteur on Torture between 2010 and 2016. And today, Juan will talk about prevention of torture and cruel and inhuman and degrading treatment and punishment in the context of the pandemic. So I'd like to hand the floor over to you, Juan. Thank you.
Thank you very much, Donna. And I'm very honored and grateful to Trinity College and to Donna and your colleagues for the invitation and particularly for the privilege of participating with such a distinguished lineup of experts. Yes, I will talk about the kind of sub-crisis that is happening together with the COVID-19 crisis, particularly in regards to persons deprived of liberty, who, as everybody knows, even if they have been convicted of crimes, they don't lose all rights, and they definitely maintain or should maintain their human dignity. The public health necessities requirements do impinge upon some individual rights and some collective rights as well. And because of that, under international human rights law, they should be analyzed under two very fundamental principles of international human rights law. The principle of necessity, which means that in the face of a pandemic, we do have a crisis that requires public policy and public action that can impinge on the exercise of rights by individuals. But that principle of necessity, which is unquestioned in the case of COVID-19, also must be met with a principle of reasonableness of the measures taken. And so that the measures taken have to be rationally related to the causes of the necessity, so that they can be implemented in a way that affects individual rights as little as possible within the context of trying to address the public health necessity. And both principles, necessity and reasonableness, should be subject to controls of a judicial nature both in general terms, but also in individual applications of measures. And particularly, I think, with civilian participation and civil society controls, and they should be also subject to requirements of transparency. We are, after all, dealing with an appropriate balance between liberty and the right to health, and particularly the right to health of others, and even the right to life, since this pandemic is so devastatingly deadly. And finally, the principle is that all of these measures should be applied without adverse discrimination on the basis of race, religion, national origin, gender, etc., and even economic and social status as well, as a proscribed basis of discrimination. But when it comes to persons deprived of liberty, we fortunately do have some guidance from international law and recent adopted guidance by authorized, authoritative organs of protection of human rights, like the Committee on the Prevention of Torture from the Council of Europe, the Subcommittee on the Prevention of Torture in the United Nations, the Inter-American Commission on Human Rights in the OAS, and fundamentally, we have the updated UN Standard Minimum Rules on the Treatment of Prisoners, now called the Nelson Mandela Rules, that establish a clear standard of medical assistance to persons deprived of liberty. Medical assistance that should not be only curative, but also preventive. Obviously, all of these things are soft law, but they're soft law that are referring to some hard law obligations on the part of states. When the pandemic started, several domestic judicial organizations and courts did in effect take some early decisions that were positive and going in the right direction. They unfortunately, many of them remained as announcements rather than actual decisions. And because the reason is because they were soon met with a backlash in public opinion, preoccupied with citizen security if you release too many prisoners out into the streets in the middle of this crisis context. But of course, that also has to do with a very low priority that the rights of persons deprived of liberty enjoy in public policy in so many different states, including states that have genuine democratic governments and institutions. The result has been that in many prisons around the world, there have been many, many deaths, that infections in prisons are rampant, that in fact, if anything, we have a serious lack of transparency. We just don't have data. In prisons, for example, in the United States, there has been testing and tracking and tracing, but without disclosing the results of those tests and tracing. And we should also remember that immigration detention in countries that are net recipients of immigrants and asylum seekers and refugees has become more the norm than the exception. And immigration detention is typically done in ad hoc and badly created detention centers where conditions to address a pandemic are non-existent, or at least they're very limited. And the first reaction around the world has been to limit visits by families and limit visits by lawyers, and in some cases to resort to solitary confinement of people, supposedly to isolate them from the general population. All of which has been done in a very ad hoc and not particularly scientific manner. so that the conditions of detention have been aggravated, but also the conditions of prevention of the spread of the disease have been aggravated by, ill-conceived measures in prisons. And the consequences also is that because it's impossible to keep the spread of the virus from coming out of the prisons, because guards and their families and all kinds of people arrive at enter and come out into the general society, the prisons themselves have become a focus of infection, but also have contributed to making the spread of COVID-19 in the general population. And I don't mean the prison population. I mean the general society population, more difficult to address because of not having a serious policy with regards to persons deprived of liberty. This crisis comes on top of a previously existing crisis of prison conditions around the world. In many, many countries, there is overcrowding. There are very bad health and conditions that attach to persons deprived of liberty. But the crisis is, at least one could hope, is also an opportunity. And maybe it is time to start thinking seriously about the abuse of preventive detention, for example, that have exacerbated overcrowding and poor health conditions in prisons, but also has affected the response of prison authorities to the COVID-19 pandemic. We need to address the abuse of preventive detention for the long term rather than to address the pandemic, because we need to reduce overcrowding, but also to make sure that we don't let prison authorities abuse solitary confinement even for health-related measures, because prolonged or indefinite solitary confinement is cruel, inhuman, and degrading treatment, and in some cases can even be considered torture of a psychological nature. And so that the remedy cannot be the abuse of solitary confinement, which unfortunately we're seeing in many countries. But we also see denial of essential benefits and rights, especially to medical attention. And the Nelson Mandela rules very clearly say that the inmate has the right to the same medical attention that is available in the community. And that applies both to curative medical attention, but also to preventive medical attention. And that means appropriate levels of food, clean water, drinking water, possibilities of work in safe conditions and of exercise, and particularly the provision of disinfectants and soap and water that unfortunately in many prisons is not available. But we also have to look at reducing prison populations by humanitarian decisions to release the earlier than the end of term of the prison term, especially for the aging inmates, but also to those who are vulnerable to COVID-19 because of pre-existing medical conditions, and to do it in a regulated and transparent fashion. I know I'm running out of time, and I know we need to let people ask questions from my very distinguished fellow panelists. So I think I'll stop here, but with a call for a reasonable and well thought through plan to reduce infections in prisons, but also reduce prison population in an orderly fashion and a humanitarian inspired fashion, so that we can not only protect the human dignity of people deprived of freedom, but also contribute more effectively to putting an end to this crisis of the pandemic that affects all of us all over the world. Thank you very much.
Thank you, Juan. We're immensely grateful for that insightful examination into international human rights law standards, in particular the right to liberty in the pandemic context. We're really delighted you could join the panel today. We're a little bit behind schedule, but I think it's very important, as promised, to let Eyal and Eric come back in if you are still here. I don't mind if we go over time by a few minutes for the Q&A, and apologies in advance that we probably have done so. But whoever is available, you're more than welcome to stay on the line. So, Eyal, would you like to take the floor?
Yeah, thank you. I'm grateful for Eric's comments and suggestions, and to the other participants who made some comments. I'm actually, for me, it was like music to my ears to hear Eric more optimistic about international law than me. I think, well, we should should be optimistic, but the point about US withdrawal, this is of course not the first time that the US withdraws from an organization where it feels it has no longer monopoly or hold of on decision making. And what the US usually does is to, move on to establish an alternative organization. And if this is the case, this may be, but things are not yet settled in the context of US's withdrawal. With respect to, I also gone from Professor Sekalala about the private framework, and Eric asked about private punishment, and Professor Sekalala asked about accountability of private organizations, and here I think there's much room for more, discussion. I think that actually I can rely on Professor Sekalala's excellent book on soft law in health governance, where she emphasizes the role of social society activists and civil society activists and organizations, and shows how effective they were, particularly in the context of HIV and access to drugs in South Africa and other places. So in the way I see the future of private or non-state alternatives to the state-run WHO, I see a role for not only private insurers and airline companies, but also civil society activists and municipalities that participate by emphasizing what policies should be, and monitoring compliance, and participate in providing private sanctions against violators. I think that's it from my perspective. Thank you very much.
Thank you, Eyal. And Eric, would you like to come back in there?
Well, I guess just a quick comment, which is I suspect what will happen is that the United States will either renegotiate, the terms of the WHO and the terms of its participation, or that it will cooperate with the WHO or countries within it without formally joining it, the way the US has, for example, with the ICC. Obviously, those are less desirable than a more formal arrangement. But I do think it'd be interesting to think about the possibility that there, as depressing as it is, that there may be a kind of bifurcation between China-dominated, US-dominated institutions, you know, echoing what happened in the Cold War. But that would be for future work, I suppose.
Thanks. It's such an important discussion. And Robert Morgan is on the line. He has a question for one of the panelists. Would you like to take the floor there, Robert?
Yeah, thanks, Donna, and thanks everyone for a wonderful afternoon. I probably speak on behalf of other students and young researchers that it's great to experience something like this online that we often don't get a chance to. And also, secondly, I'd like to thank Professor Lyons as well. But she's always helpful to her students, and it's great help to me in my study of human rights. So specifically, my question was for Juan around torture, and I'm specifically interested in asking about how worried you are of governments illegally detaining citizens and political opponents on the cover of the pandemic. And secondly, with the preoccupation of governments around the world, how do you think the influence of international organizations in responding to human rights abuses such as genocide and torture, which still go on today, how do you think their influence will either increase or decrease given the country's preoccupation with the current crisis? Thank you.
Thank you, Robert. Juan, would you like to come in on that?
Yes, thank you very much. It's an excellent question. Actually, COVID-19 has many dimensions of threats to human rights in general, and particularly, again, I would say to democracy. We've seen lots of suspensions of elections, for example, some merely temporary, and that on the positive side, it may force states, if they are in good faith, to start looking at modernizing voting systems, for example. But we've also seen examples of autocrats grabbing power, dissolving courts and legislatures, etc. And unfortunately, in some cases, with some popular support. I don't have an answer for that in terms of political persecution. I haven't seen examples of using the excuse of COVID-19 to detain political opponents. But I am sure that with all the risks that some of my predecessors in the podium have mentioned about privacy law and the lack of controls over investigations of this sort, that if not immediate imprisonment, certainly undue surveillance for political reasons of political opponents will be a problem that we're going to face. I do think that with all of that, we have international law being a good backup to domestic courts if they are willing to play the role of controlling public policy decisions of the executive and even of the legislative branch. Unfortunately, in many countries around the world, the judiciary is not strong enough to withstand this crisis and play its role of effective control of abuses of power. But we should put them up to the test, and we should bring the appropriate cases where we need to make sure that the principles of necessity and of reasonableness that I mentioned at the beginning of my prepared remarks are applied in specific cases and in specific contexts. And I think sooner or later we're going to have some very good international law standards on this matter. I think they are already, more prevalent when it comes to deprivation of liberty, and in that case, I think I would wish that we could see domestic courts stand up and control administrative decisions much more thoroughly than has been the case so far. With respect to genocide, crimes against humanity, war crimes, I think that question would probably be better answered by Judge Morrison. So I'll stop here.
Would you like to come in on that, Howard? No pressure.
Well, the short answer is that we would love to be able to do more than we can. We rely upon domestic courts understanding the complementarity provisions of the Rome Statute. I'm afraid some seem to understand it better than others. We're not there to replace national courts. We're there to supplement them where they cannot work or will not work. But at the end of the day, last speaker was absolutely right. A lot depends on the strength of the judges and the degree to which they can exercise their judicial independence. Now, I've been lucky throughout my judicial career that I've never been even remotely lent upon by any politician or quasi-politician, and it wouldn't be a great idea if they tried. But there are instances where we know it happens, and we know where under populist politics, rule of law, open society, which affects NGOs, of course, greatly, come under enormous pressure. One of the questions was, what about NGOs? NGOs are absolutely vital. We have at the ICC the Coalition for the International Criminal Court as an umbrella organisation, which has under its mandate many NGOs, and we couldn't work without them. We need their input in the same way that we need the input of interns and professional visitors. Some are better than others, some are better funded than others, some are much better known. And I would pick out, for instance, Amnesty International, Human Rights Watch and Justice, not to exclude anybody, but simply to say those are organisations which constantly put their heads above the trench and make their voices heard. And they're very, very valuable voices, because ICC is a small court. And when I sat as a judge in the UK, in Birmingham Crown Court mainly, we had 20 courtrooms going simultaneously. That's one court in one provincial city. The ICC, the idea of being a world court, we have 3 courtrooms. We have 18 judges, of whom 13 do trial and pre-trial work, and 5 of us are in appeals. We are a small court, which is why I emphasize we need all help we can get from concerned people. But let me say this, and this is just an old man waffling, I know, but nationalism and internationalism tend to go in sort of sine waves. There's a few decades of one and then a few decades of the other. And if you look back through recorded history, I think there are some very good examples of that. The ICC wouldn't be started now. It was started in the heady days of the early 2000s, when internationalism and multinationalism, multiculturalism, and an expansion of human rights was very much to the fore. Now that's being picked on, it's in decline. Nationalism and false arguments about sovereignty, loss of sovereignty are dominating. But I say to the young people, that won't last. History shows us that things rise and fall, empires are created, divided, and disappear. So you've just got to hang on to your principles and your beliefs.
Thank you for that very positive note, Howard. We had a question come in advance through our email by Raman Malashanka. So Raman asks, to what extent, if any, could China be held liable internationally for the spread of COVID-19, and could there be any consequences for that country, e.g. payment of reparations to other countries? So a controversial question. Would anyone like to come in on that? struck me that Professor McCrudden might have views, but I'm not sure whether he's still with us. Professor McCrudden, any thoughts on that?
He is, but Eric Posner is sitting in the place where the litigation has started already. I suspect the American courts are going to try to deal with that, at least at some level. Good luck with the remedies.
Would you like to take it up, Eric?
Well, I mean, I think there's no chance. I mean, that's the short answer. There's zero chance that China will be held liable, both under, I mean, in the United States, there are legal constraints, but of course the country is just far too powerful.
Thank you, excellent. I suppose we should finish up shortly. Maybe one final question. Let me see, I think we've asked some of the first ones here. From Ikamafuna Stephen Noy, thank you to the panelists for the wonderful presentations. It was nostalgic to sit in for the presentation by Professor Benedict Kingsbury, who taught advanced international law to me at NYU. A special thank you to Donna Lyons, and there is no question. Lots of thank yous, lots of compliments. Let me see if I can. Yeah, one question on civil society, which I think we've answered. For Judge Morrison, again, to put you under the spotlight, if you had to predict what type of cases you might see arising in the near future in relation to the crisis, such as cases seeking reparation for loss of wages, what would you predict as the next big issue for the courts? That's from Sabrina.
Right. A lot of these issues are more likely to be cases applicable to the International Court of Justice and to Permanent Court of Arbitration rather than to the ICC. It's, you know, we deal with criminal responsibility to individuals. Reparations only raises its head after somebody's been convicted. And I've got strong views on reparations, but I won't air them here. I don't think they're matters that judges are particularly well suited for. You really need experts on the society, which is grossly affected by the offences, to deal with reparations issues. But that means redrafting the Rome Statute, and it would be easier to redraft the American gun laws than it would be to redraft the Rome Statute in some issues. But the short answer is this, that this is something that domestic courts should be dealing with in the first instance, domestic courts and tribunals. Very difficult, though, to attribute fault unless you can show that a government policy in dealing with COVID-19 and the consequences was so grossly negligent that it amounted to some form of tortious liability, or perhaps in individual cases even contractual liability. But I think this is we're all paying the price, I'm afraid, for COVID-19, and we're going to be paying it for a long time.
Thanks for that helpful intervention on a difficult question. We will have to wrap up shortly. Is there anything any of the panelists would like to raise before we do? Any questions you'd like to ask of each other, or any final points? You're very welcome to come in at this point. Okay, so I'd just like to say a final thank you, a very big thank you to all of our distinguished speakers. There really aren't words to express our gratitude for your participation today. It's been very useful. We've spoken about the challenges that COVID has brought to public international law, but also that there are potential solutions, and it's been wonderful to be able to explore those with you today. And one of the silver linings bringing together a panel like this is that we are using the technology to come together and have these high-level discussions, and it's wonderful that we're able to accommodate public participation in a way that might not have been possible if this was in-house or within a university, within the walls of the university. So I think the audience will be very grateful for having had the opportunity to participate in this today. And hopefully we can have a follow-up discussion later in the year. It'd be lovely to keep in touch and maybe to organise another discussion with the same panelists and possibly some other participants. So final thank you to everyone. This will be made available online for anyone who couldn't tune in. And with that, I will close the session. Thank you again.
Thank you.